Hello, everybody. All was not well for a moment. I thought I was going to have to call the National Guard, and I needed helicopters, I needed drones, I was having a panic attack, couldn't find my coffee. And I went to the bathroom because I took a shower, and, I thought maybe I left it in there, it wasn't in the kitchen. Come back in here. We're okay. It was behind my hand lotion. So I didn't see it. But we're all good now. I'm okay. I'm okay. Oh, I need to put a tile on that thing or something. We cannot have another mishap like that. Oh, April without coffee. I rue the day. Oh, hello, Nana Laura. Hello, Auntie M. I'm so happy to see you. Hello, Sir Philip. I'm so happy you're here. Sir Philip came and joined the premiere yesterday, and I didn't see him because I was driving and trying not to read chat when I was driving. So, yeah. I felt really terrible. I'm like, I saw his goodbye, and I'm like, oh, he was here. Hello, Ava. Ava's such a good girl. Did you guys see Ava's a judge now? I love it. I got it done, and then I messaged Joey and Sir Philip and Auntie M, and I'm like, I gotta show you something. We gotta meet right now. Thank you so much. Yes, I was so excited to have it done. I made it myself. I did that. Hello, C-Rex, my love. Thank you so much, Nana Laura. Hello, Fozzie in Texas, honey. Oh my gosh, I'm so grateful for that. Thank you. I appreciate that so much. I'm sorry. I'm giggling. I'm sorry, Fozzie. Joining my membership just caused a hold on Fozzie's bank account. They're like, are you sure you want to do this? Do you really, really want to do this? I'm sorry. Hello, is that Panette, honey? Hello, Eileen E. Carlin, honey. You should have seen me last night. Oh my gosh. So hold on. I gotta get through my greetings, and then I'll tell you the story real quick. Hello, Linda Applegate, honey. Hello, Mortimer Duke. Ooh, the pimp stick. That's all the more reason for me to act up more, isn't it? No. I don't even know what to do with one. Hello, Jenny. Oh, you guys are the best, Spider-Man. Hello, love. I know. I will protect you from Billy. I will protect the Ava. So last night Oh, do not give me ideas. Don't do it. Don't do it. How dare you? They're going to hate you. Oh, look at Billy just mean mugging Ava like that. Oh my gosh. Oh, you grumpy old man. I love you. You're like a Sir Philip in feline form. All the more reason to love you. He hates it. He thoroughly hates it. Your neck's not broken, dude. It's just sitting on top of your head. Okay, so last night I was supposed to have a friend stop over. I thought they were going to stop over, but then they had to stay at work late because they have one of these amazing jobs that the schedule's like flexi. So, they're supposed to be done at a certain time, but they don't. Like their boss can say, "Hey, I need you to finish that up," and then they have to stay. So I was like, yeah, kind of bummed. I miss my friend, and human contact is, kind of cool sometimes. So, I just, you know what? I decided I was just going to be happy anyways. And I was going to wait for them. I didn't know what time they'd get done. Around like 1 a.m. or something like that. They said, "I'm almost done, getting ready to leave." Yeah, they didn't get home until like nearly 7 in the morning. And by that point, docket harvesting is starting, and they just went to bed. Like, Earl, Ava, you leave Earl alone. You quit that. But yeah, I stayed up editing videos all night, the whole docket that we have tonight. I made thumbnails for each video. That'll save me on replay crew time. It's a win-win. And I danced with Ava. I sang songs. I played with the kitty cats. I reached out to a couple of my amazing subscribers that I know have had health issues recently, and they had personally messaged me in Discord and talked to me. So I replied to them and sent them some videos to cheer them up. And, I made the best of the night. And you know what? It was the best night. I had so much fun by myself with my pets. Like, I could have just sat here and been like, "Oh, poor me, my friend can't come over." No, that's not how I can't do that. I can't do that because you know what? I don't get enough days on this earth. I'm going to choose to be happy every chance that I can, because happiness is a choice. Yeah, you get bummed sometimes, but you don't have to stay that way. Yeah, this is Billy O.T. He's my baby. He's my grumpy old man, even though he's not even the oldest one. Oh, I gotta turn that heater down. Hey, no biting the mama. No biting the mama. He says, "You put the hat on me, woman." Hello, Tiana Miller, honey. Thank you guys all for coming out. We are gonna have a blast tonight. It's gonna be so much fun. I got multiple different judges, multiple hearings, cases. I was up all night, and then I slept like an hour and a half, maybe ish today. So yeah, this is what you get. Oh yeah, it sure is. Yeah. Hey man, I almost lost it. I almost didn't get to have this life a couple of times. I'm going to make the most of it. It's mine now. No one can take it from me. I plan on living forever, and so far, I'm doing pretty good. You have seen me this way before. All right, guys, I need to turn that heater down. So I'm going to put the case on and then turn the heater down and then be right back. Yeah, Zanny Joanne, her sentencing.
The next matter before the court is State of Kansas versus Joanna Lee Carson, Greenwood County case number 2024 CR 14. Jill Gillette appears as Greenwood County attorney, Chris Ambrose as defense counsel, defendant Carson appearing from the Greenwood County Jail's Zoom location. This matter comes before the court at this time for sentencing. Docket notes of the court would indicate that the defendant appeared before this court on October the 31st. At that time, she had pled guilty to count 1, driving under the influence, a Class B misdemeanor, and count 2, possession of methamphetamine, a level 5 drug felony. Pre-sentence report was ordered, and sentencing originally set for December the 26th. Defendant did not appear on December the 26th. The docket notes also reflect that at that point, the defendant had not completed all assessments that she was required to complete. The court ordered a bond forfeiture bench warrant with a no bond hold. She was subsequently brought before the magistrate court on December the 30th. Sentencing was rescheduled to today. Court now has a completed pre-sentence investigation report compiled by Ryan Smith, pre-sentence investigator. I trust each attorney has received a copy of this report. And I'll ask the state's attorney first, is there any objection to the criminal history which is stated in this report?
No objection to criminal history.
Any objection by the defense, Mr. Ambrose?
No, Your Honor.
Ms. Gillette, do you know of any legal reason why sentence should not be pronounced in this case at this time?
I do not, Your Honor.
Mr. Ambrose, are you aware of any such legal reason?
No, Your Honor.
Carson, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing?
No.
Or proceed further then? Court's not aware that there's been any departure or other motion to be considered by the court. Does the state have any motions to argue at this time?
It does not.
Does the defense, Mr. Ambrose?
No, Your Honor.
There's really nothing to argue.
Is there any victim or members of a victim's family present who desires to address the court in relation to this sentencing? Court finds no such persons present, so the court will ask for recommendations from counsel regarding an appropriate sentence for Ms. Carson, beginning with Jill Gillette on behalf of the state.
Yes, Your Honor. This was a case when we discussed the plea. We had anticipated that this would be a Senate bill type of case. I believed that she would qualify, which she did. The standard box is 20 months, where that's what we will be recommending, with up to 20% good time credit and up to 12 months post-release supervision. Probation up to 18 months, mandatory Senate Bill 123 treatment. This was count 2 that she pled to as the first conviction. The second one is DUI. The driving under the influence is scored as a Class B misdemeanor. I do know there was one still pending up in Johnson County. Not sure what happened to it, but based on the criminal history that the court services was able to obtain, this is a Class B. We would recommend 6 months underlying suspended for probation. We have the Senate bill, SASE, which would equate to having the drug and alcohol evaluation for a DUI. We'd ask that she follow all recommendations in the DUI as part of her probation. I don't have an objection to both of those counts running concurrent. Ms. Carson has spent the last 28 days in custody, having been picked up 12/26, and today being 1/23. I believe that that 28 days would cover any, there isn't any mandatory now on a first, but I do believe that it would cover the jail time that the state would ask for not participating in her PSI. I don't want to see Miss Carson back in custody. So I am not asking for any jail time as a condition of her probation. I am going to recommend that she start her probation in Senate bill today as the state's recommendation, Your Honor. There is, in this case, lots of different costs. Ms. Carson has court costs of $193 as a felony. There is KBI Labs for $400. There is a booking and fingerprint fee of $45. DNA database, I believe, is already on file. She has provided a DNA sample. She does have a prior felony in Barber County, Kansas, so I believe that covers it, as well as Crawford. So she should have already paid the $200. There is a fine recommended for first-time DUI of $750 because her case is being sent to community corrections. There is a box on the journal entry where we can assign $250 of the fine amount to community corrections, as well as the correctional supervision fees that helps take care of the extra DUI requirements that community corrections oversees. So I'd ask that that be allowed to be sent to the Community Corrections Fund. There is the Senate Bill 123 reimbursement and assessment fees. Then I'd ask the court to inquire pursuant to Robinson as the bid's attorney and application fees. Believe that she does have a total jail credit of 29 days. She did have one prior day that counted from 1/7 of 24. And we'd ask the court to grant the 29 days. I am not aware of any other cases that would be concurrent or consecutive at this time, unless I've missed them somewhere when I reviewed the PSI. I was aware there was a Johnson County possible, or city of Olathe or somewhere up there, a municipal DUI pending, and I don't know what happened with it. Other than that, that is what I am aware of, Your Honor.
Very well. Your recommendations, Mr. Ambrose?
Yes, Your Honor. As far as what we're going to be doing is with Ms. Carson regarding disposition, I don't have any. We're joining the state essentially that I believe it's appropriate. A standard 20-month underlying sentence on the felony and appropriate underlined on the DUI. Ask that they be ran concurrent. Be an 18-month probationary period case. I think that the one area where I'd ask the court some consideration is in costs and fees in this case. I know that we do have a statutory mandatory minimum arising out of the DUI case that we can't do anything about. However, I would note for the court that Ms. Carson, currently unemployed and is on disability, her disability payment's approximately $900 a month. She's going to have some substantial costs arising out of this case. In light of all that, I'd ask the court to waive or abate the bid's application and attorney's fees in this, and any other court fees and any other costs or fees the court would deem appropriate. Would note that Ms. Carson has been in custody 28 days since the end of December awaiting sentencing. Would ask the court to not exercise any quote unquote shock time as a condition of her probation. It does look like Ms. Carson was open and honest with the evaluator in this case, and they do kind of the extent of her drug history is relatively clear, and her need for treatment is as well. And just talking with her briefly, I think she's looking forward to have that opportunity to get to inpatient and then move towards reintegration and do what she needs to there, so she can be successful moving forward.
And how much are your fees in the representation of this client, Mr. Ambrose?
Yes, Your Honor, sorry. You're to be right at $2,000 by the time we're done.
Very well. This time, the court will address the defendant, Joanna Carson, personally and ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court. Ms. Carson?
No, I don't. Thank you.
Court pronounced sentence in the case at this time. Court hereby establishes count 2 as the base sentence in the case for the offense of possession of a controlled substance, a severity of level 5, drug, non-person felony, in which the defendant has a criminal history score of E, thus placing her in grid box 5, drug E. The court hereby sentences the defendant to a term of 20 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed on that count. Relating to the additional offense in count 1, driving under the influence, a Class B non-person misdemeanor, the court will impose 6 months in the Greenwood County Jail, run that time concurrently with the time imposed on the felony count, and the court will impose a $750 fine for that offense. As there's been no suggestion here that a community service payment plan would be feasible under these circumstances. This court will also be assessing felony docket fee, felony probation fee, community corrections fee, $400 restitution to the KBI laboratory, a $45 booking and fingerprint fee, and order $300 reimbursement to the Senate Bill 123 program. As this is a mandatory case for Senate Bill 123, the court finding that due to the severity level of the offense combined with the high awareness score and the high probability of a substance abuse disorder in the assessment, the court does deem it a mandatory case for Senate Bill 123 state-sponsored treatment program. And the defendant is committed to that program as part of a community corrections probation for up to 18 months. I will note for the record that the current recommendation before the court regarding services in treatment would be level 2 intensive outpatient services, eventually decreasing to level 1 outpatient treatment, including relapse prevention services, peer mentor, and family services as needed or available. Obviously, any aftercare recommendations which are made by the treatment provider will be ordered as conditions of probation in the case.
So she's getting some real jail time for the offense. And I think just the multitude of hearings that they've had to have with her in relation to her drug offenses and the fact that she showed up to one of them under the influence, it might have something to do with it. Judge Ricky's actually quite nice to her, all things considered.
Other probation conditions will include reporting to an officer as directed. Defendant must observe all laws. Obviously, she has to complete her treatment program as recommended by the assessment provider. She shall not possess or consume alcohol or illegal drugs while on probation. At her supervising officer's request and at her own expense, she shall submit to random breath, blood, and urinalysis testing, perform community service work pursuant to any program requirements. Unless shown to be legally disabled, she must gain and maintain employment throughout her probationary term. Notify her supervising officer of any changes in employment status, disability status, residence, telephone number, or email address within 24 hours of any such change taking place. Have no contact with disreputable characters and places. Attend a presentation by the DUI Victim Impact Panel. abide by any curfew or travel restrictions imposed by her officer. The court does waive all bids assessments in the case in light of the considerable costs otherwise imposed in this case. Ms. Carson, I do need to establish a monthly payment amount. Now, I'm going to presuppose you're going to be receiving, based on what was announced here, some sort of disability subsidy. How much is that?
About $900. 900.
Can you commit to at least $50 a month minimum?
Yes.
What will
And if I
require
can-
$50 a month minimum starting with February
Yes.
2025 and all subsequent months until paid in full? I do note that the defendant has earned 29 days of jail time credit to be reflected by the sentencing journal entry. At some point in the future, Ms. Carson, you may have the right to seek expungement of one or more of these offenses. Certain statutory limitations do apply. If you have any question about your right to seek expungement of either of these offenses, you may address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant in Kansas has a right to appeal their conviction to an appellate court having jurisdiction, and defendants are unable to pay the cost of an appeal. They may request the court to appoint a lawyer to represent them on appeal, and to have the court direct that the defendant be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Greenwood County, Kansas. You do have the right to appeal this sentence. If the court has ruled adversely to you at this hearing, I will remind you that there's prohibitions against a convicted felon possessing a firearm, and there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Carson, do you have other holds on you?
Not that I know of. I don't know.
Okay. Ms. Gillette, do you know? Does she have other holds on her?
I'm not aware of any.
Okay. Ms. Carson, presupposing that the sheriff's office is not aware of any additional holds, I'm going to order you released today
Okay.
to start your community corrections program. I have Ed Ketley here from the 13th Judicial District's Community Corrections Department. He may have some directions he needs to give you. Do you want to do that now, or do you want to talk to her after we're done with court, Mr. Ketley?
We can just get a breakout room when we're finished with court, Your Honor.
All right, so when we recess the court proceedings, Ms. Carson, I need you to stay on the Zoom meeting. You're going to visit a little bit with ISO Ketley, and then he's going to give you some further direction about what you need to do to get successfully started on your community corrections program, okay?
Thank you.
Your Honor, if
All right.
I may,
Yes.
Your I may have misheard Your Honor earlier when reading the recommendations from the drug and alcohol evaluator. It appears that she was recommended to attend immediate inpatient services followed by reintegration. And I will advise the court that more recently than I distributed the PSI, I received a letter stating that she has an inpatient bed date scheduled for tomorrow morning, it appears.
Oh,
I just wanted the court to be aware of that and know that that was the recommendation.
is it with that same program?
I'm,
Inpatient bed?
ATC
it's at ATC, Your Honor.
in Pittsburgh,
Okay.
Kansas. Yeah.
So noted. That is indicated by the evaluation, Mr. Smith, that the initial diagnosis and suggestion is that she be admitted to an intermediate inpatient services program, then followed by the other outpatient services that the court mentioned. I'm pleased that there's a bed available so quickly, Ms. Carson, so that you can get started with your treatment, which is quite clear to the court that you need.
Yeah.
And I hope that you're very successful in your treatment programs.
Thank you.
So I will expect you to report and fill that bed that's been opened up for you. All right.
Thank you, Your Honor.
Okay. Let me ask Ms. Gillette, is there anything further that the court needs to address regarding Carson sentencing matters?
Judge, I did not hear you say whether or not $250 of the DUI fine can go to community corrections.
If Statutorily allowed? Yes.
That's the only other box I had. Thank you, Your Honor.
All right. Mr. Ambrose, is there anything further we need to address here?
Not for me, Judge. Thank you.
Ms. Carson, do you have any questions about the court sentencing orders?
I don't.
All right. Good luck. I truly do hope that you're successful on this probation and treatment program.
Thank you.
I'll have you stay on the meeting. We're going to recess and stop recording and broadcasting in this case, but leave the Zoom meeting open so that Mr. Ketley can visit with the defendant in this case.
Thank you.
We followed her probably from the beginning. I don't know if there was a hearing before it or not. I don't think so, but I really do hope she's able to find sobriety. She needs it, as the court said. And I hope the best for her in her inpatient treatment. She's got a long jail sentence looming over her head. So you are licking my mouth. This is not the kind of mouse that you're supposed to lick. But I probably got a little licky treat spilled on it when I was giving some to you and Billy, didn't I? All right, yeah, okay. All right, so let's watch an attorney fall on her sword.
I have Brett Crandall and Miranda Bailey Quick turn their screens on, please.
This is Brent from District Court.
Thank you. We're here on 3 felony matters. I believe there are probation violation hearings on one. And felony status review on a couple others. Last time, my memory is last time we were here, Ms. Bailey Quick, you asked for an opportunity to apply for drug court for your client. What's the status of that?
My client had the wrong phone number. He inadvertently transposed the last 2 numbers. He was unable to meet with Mr. Hamlin on Friday last week. I was unable to get him any arrangements to have a substance abuse evaluation by today. He is, however, set for a substance abuse evaluation on next Friday at 1 p.m. That was the soonest I could get him in or scheduled. At this point, it's my understanding that in essence, I believe Mr. Hamlin indicated to Mr. Crandall he just wants the court to decide whether he should pursue it or not. And if that's the case, my client willing to just waive preliminary exam and move forward.
Where's your client at physically?
He lives in Johannesburg, Your Honor.
So why wasn't he at the courthouse at 8 a.m. on Friday last week?
He was working.
Well, gee,
Right after the sorry, go ahead.
I'm going to say he asked me specially to make an exception for him, and we gave him a day to get there. He was told to appear at 8 a.m. and then he's going to say he's got to go to work.
Well, right after the hearing, he spoke to his boss, and his boss said, if you're not here tomorrow, then you essentially are losing your job. So he tried getting a hold of Mr. Hamlin to reschedule. His boss said he needed more than 12 hours notice, and he wasn't able to reach Mr. Hamlin. He left a voicemail, called back again, left another voicemail. It wasn't until today that he figured out with my office that he transposed the last 2 numbers.
How's he going to do drug court if he can't get off work?
Well, we've talked about that at length. It was just a matter of the short notice between 3 o'clock last Thursday and needing to be there at 8 a.m.
I think you can tell by my demeanor that I'm not exactly pleased. Why should I give Mr. Crandall a fourth bite at the apple?
Well, I don't really have a response for that, Your Honor. I will just tell you from a practitioner standpoint, this has been the most frustrating process that I've dealt with, frankly, with any court. Trying to just get and I sit as the defense team member for Veterans Court in Montmorency County. And I have struggled even trying to figure out what the process is. We were asked to do one thing. I scrambled trying to call in favors to get a substance abuse evaluation. Had I known 3 months ago that he needed the substance abuse evaluation before he met with, or contemporaneous with when he met with Mr. Hamlin, I would have had him do that immediately. This, again, has been the most frustrating process for me, even as a practitioner.
When did you start in the case, Ms. Bailey Quick?
From the beginning, Your Honor. I think he appeared at arraignment by himself, and ever since then, I've been in the case.
That's a bold move.
This, as far as I can show, the original interview was scheduled for November 8th of last year. Are you trying to tell me you can't figure it out since then? How much
I'm
time?
not trying to lay or point blame anywhere. I think at this point, my client is willing to forego it. It was certainly something he was entertaining and wanted to participate in, but again, I myself have left messages. I've reached out to prosecutors. Again, this has been extremely frustrating for me even. So I will take the fault for it, but at this point, I don't have an answer for the court.
I'm sorry, you misunderstood my area of inquiry. I'm not looking for somebody to blame. I apologize if that was the response that you took from that. I'm trying to assess whether or not Mr. Crandall is going to be able to make it through the drug court process, because quite frankly, it is by definition a huge inconvenience. That is almost the sole purpose of being in drug court, is to inconvenience you to the point where you change your behavior. That is exactly what it's designed to do. So if we have inconveniences getting in the way now, it's sometimes better to just realize that isn't going to work and he may not be a good candidate for it. And that's kind of what I'm trying to assess at this point. So I'm not trying to point fingers and say somebody did something wrong. I'm just trying to figure out if this is going to be too much for him. We might as well say that now. And so it sounds like that's where he's at. Am I correct with that, Ms. Bailey Quick?
I would defer to Mr. Crandall.
Mr. Crandall, do you want one more crack at this or not?
Yes, Your Honor. I'm willing to meet with Luke and have my interview. I have no excuse. That's completely on me. I had his phone number mixed up and was unable to speak with him until today. And
well, we're not going to do phone numbers anymore then. So we're not going to do phone numbers. You're going to have to come here in person when he says he wants you here. And quite frankly, you're going to have to get off work to do that, most likely. You understand that?
Yes, I do.
Mr. Hamlin, when would it be convenient for you to do this assessment and evaluation?
Judge, there's a couple of things here. It makes it a little bit difficult. He did call earlier today. My best day would be tomorrow. However, he's got to leave town and go to Detroit for a funeral. I understand unexpected circumstances do happen, and I do try to arrange my schedule to the best of my ability. But given next week we have drug court on Tuesday, the best option I have is, Friday the 31st again. It would be at 8 o'clock. And then we don't have another drug court until February 11th. So I leave it at the court's discretion with what to do with the matter of this case, because we are pushing limits, in my opinion.
No, I get it that we're pushing limits. And is Friday, February the 7th open for you, Mr. Hamlin?
Yes, Your Honor.
Mr. Crandall, that gives you almost 2 weeks to get the time off to be there in person at 8 a.m. on Friday the 7th. Can you do that?
Yes, Your Honor.
Ms. Bailey Quick, when is his assessment, his substance abuse assessment?
The 31st at 1 p.m.
You would think that his boss would want him to be getting the help with this problem. I mean, I would think any boss would be more than encouraging to get their employee sober.
So he could have that in hand when he spoke with Mr. Hamlin?
I can
Doubtful.
certainly ask the evaluator to have that to me by, it usually takes a couple days after, but I mean, I know they usually ask for longer than even a couple days, but I can ask to have it by the 4th at the latest.
Well, he'd have until the 6th, Thursday.
Okay.
Well, Mr. Hamlin, do you need that or do you want that information?
Well, I would need that before court produces
You bet.
sentence, Your Honor. So I would, if I could get him here on Friday the 31st for an interview, then he can maneuver around with his assessment requirements, and I'll be able to get everything ready for the court on February 11th in no time.
Can we do that, Mr. Crandall?
Yes, Your Honor.
The 31st at 8 a.m.?
Yes, sir.
Yes, sir.
All right, it's a deal. Just know this, you're on a short leash. Don't be asking for special favors. Don't be looking for special things to be done. This is on you. Got it?
I understand.
All right, for today's purposes, Ms. Bailey Quick, are you looking to waive preliminary examination still, or what is your pleasure?
Well, if he's going to be considered for treatment court, then we would remain in district court, is my understanding.
Mr. Hamlin, how do we typically deal with this? Just adjourn it and see what the assessment is and whether he's going to get in or not, and then come back and put the agreement on the record?
Yeah, I can say that, and I would also stipulate to you that if time does determine certain arguments, we could possibly put him on some sort of bond conditions, but that would all be to be determined. And I'd also request the court, Your Honor, that he gets a hold of Jessica Van Wolfen with Community Corrections too.
Your Honor, I did attempt to contact Mr. Crandall on the 17th and the 21st. The phone number that I still have back from when we spoke in November, which was the first time that we had spoke about drug court, and I sent the referral to Catholic Human Services for the assessment back on 11/7, I believe it was. So the referral was sent, it was just not followed up with a phone call, so.
Thank you, Ms. Van Wolfen.
You're welcome.
Mr. Crandall, do you have a way to get a hold of Ms. Van Wolfen right now?
Yes, sir.
All right.
What is that number?
Yeah, could I get that number?
It's 989.
Thank you.
All right, Ms. Bailey Quick, as to file 42542, that's a misdemeanor case. It's set for a probation violation. I'm assuming you just want to adjourn that. Is that correct?
Yes, please.
All right, that's what we'll do in that file. In 43076 FY, you want me to just set it out for, we got 3 weeks for the drug court assessment, and we would have to wait. I don't know, I believe he's probably already waived the 21-day rule, but if not, he would have to do that. Is that what you'd like to do?
Yes, so you're looking at the 13th?
I believe so, yes.
That would be fine. And he has waived the 21-day rule.
All right, so I'm just going to adjourn that. Mr. Crandall, you understand that you have an absolute right to have a preliminary examination. Typically, you'd have the right to have that within 21 days, but to allow us to have time to make this assessment, we'd have to go outside that time period. Is that with your permission?
Yes, sir.
All right, that's what we'll do then.
Your Honor, is that also right at 1:30 I asked because I'm scheduled for an all-day seminar on that day, but I'll step out for that.
Yeah, typically we would do those at 1:30,
Okay.
and I'll try to have staff remind me to take your case first so that you can get in and out quickly. We may be able to do that a few minutes before that if that assists in your time schedule.
That would be great. We resume at 1:30, so that would be great if possible.
I'll have staff try to remind me to be in here by 1:15 or 1:20, and we'll take care of it then.
Thank you.
And then as to file 42866, again, felony status conference. I'm assuming you want to do the same thing we just did in the last case, which is adjourn it for the drug court referral.
Yes, please.
All right, that's what we'll do. Don't let me down, Mr. Crandall.
Thank you, Your Honor.
Thank you.
Good luck to you. Yep. Thank you, Mr. Hamlin.
Thank you, Judge.
Throw that in that file.
All right, guys. We've got to show this poor guy some love. I mean it. I mean it. Like, my heart goes out to this guy. Oh, talk about a bad day.
All right, the next case is Barry Wallace. File 24-43298 SM.
Larry Brown on behalf of Mr. Wallace, Your Honor.
We have Mr. Wallace with us.
Yes, sir.
Could you turn your camera on, please? All right. Thank you, Mr. Wallace. Thank you for being here today. Mr. Brown, have we reached a resolution of this case?
I don't believe there was actually an offer in this matter. I will defer to Ms. Bruker. I believe this might be just a drunken disorderly. Is there any offer in this matter, Ms. Bruker?
No, Mr. Brown, there is not.
I did have a conversation with Mr. Wallace, and that was my understanding as well. I believe he will just plead as charged. And I think
discharged.
plead
charged.
Plead
as charged. I heard that he will be discharged.
Oh,
and I thought that's interesting. All right. So, Mr. Wallace, you've heard what the attorneys have said. Is that what you want to do today?
Yes, that's all.
You understand that you have a right to have a contested hearing or a trial?
Yes, sir.
But you also have the right to plead guilty, as Mr. Brown has said. So let me tell you what your trial rights are so that you understand what you're giving up or waiving if you enter a plea today. You have the right to have a trial, and that would be in front of either a judge or a jury. You have the right to have witnesses appear on your behalf, and you have the right to have a subpoena or an order from the court to make those witnesses appear and testify on your behalf. You have the right to call witnesses, to see, hear, and question all the witnesses, and you have the right to testify yourself or to remain silent as you choose. And if you choose to remain silent, that silence could not be used against you because you have an absolute right against self-incrimination. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof be on the prosecutor at all times. Do you understand each of those rights that I've just read to you?
Yes, Your Worship.
Do you have any questions about any of those rights?
No, Your Worship.
Do you wish to have any additional time to speak with your attorney about that?
I don't know. You'll have to defer that to my attorney, sir.
Well, I'm asking if you have any questions for your attorney about those rights.
No, sir, not at the time.
All right. Do you understand that all of your trial rights would be given up other than your right to have the attorney if you enter a plea today?
Yes, sir.
All right. I'm going to ask you to raise your right hand so I can swear you in. You swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Worship.
All right. The charge against you says that on or about November 23rd of 2024 in Otsego County, specifically on West Main Street near North Ohio Avenue, that you were a disorderly person because you were drunk in public. Is that true?
Yes, Your Worship.
Do you remember how much alcohol you had to drink before you were stopped by the police?
No, Your Worship.
What did you do out on West Main Street or North Ohio that made you disorderly? Just being drunk in public?
I was just walking. I just was walking, and they probably noticed I was staggering a little bit, so they stopped me.
Did you believe at that time that you were intoxicated?
Yes, but not completely out of it that I couldn't be coherent.
All right.
But I did have a high alcohol level.
All right. Mr. Brown, are you satisfied that we have a proper factual basis?
Yes, Judge.
Ms. Bruker, same?
Yes, Your Honor.
You satisfied that I've complied with the court rule as well?
Yes, Your Honor.
Yes, Your Honor.
All right, let me catch up on my paperwork here. All right, Mr. Brown, are you asking to proceed directly to sentencing?
Yes, Judge.
Ms. Bruker, any objection?
No, Your Honor.
Will I have a chance to explain exactly what happened that day that brought me to that situation?
You will in just a minute. I'm going to ask the attorneys to go first, and then I'm going to save the best for last and give you that opportunity. All right?
Thank you, Your Worship.
You're welcome. Mr. Brown, go ahead.
Thank you, Your Honor. Mr. Wallace, he had a lot to drink. He was out, I believe he was walking down the road. He was just causing a little bit of a disturbance, perhaps. He is not a United States citizen. He is here on a work visa. It is my understanding that he is going to be going back to the Bahamas here in about a month when his work visa expires. No one was injured in this incident. It was a very bad decision upon his part. He understands that. I would ask the court to take those things into consideration when imposing a sentence. This is, again, it is not a high severity misdemeanor. I believe there's a presumption against no jail time. While the court may want to impose some probation, I would still ask the court to consider the fact that his visa is going to be expiring soon and he needs to get home country. I would ask the court to impose fines and costs.
I really hope this does not mess with his work visa.
Ms. Bruker, any comments?
I just know it could have been a really dangerous situation for him. He was walking in the road. He almost got hit by a car. And those things sometimes cause a lot of issues. So that's all I wanted the court to be aware of. I'll leave it to the court's discretion how the court wishes to sentence.
All right, Mr. Wallace, this is your opportunity to tell me a little bit about yourself and the circumstances of this case. So whatever it is that you want me to know, please go ahead.
Brace yourselves, guys.
Okay. On the day in question, earlier that morning, I'm married. I've been married for 2 years at the time. It was a few weeks before my 3rd year anniversary, and like I'm here in the States working and sending money back and forth. So my wife called me, and the first thing she said to me was, "Don't speak, just listen." And she told me that she was pregnant. So I was like, that should be a happy moment. She was like, she's pregnant for somebody else. And she took all my stuff and took it by my mom. And I told her, because for the time we've been married for the last 2 years, 2 or 3 years, she's cheated on me over 7, 8 times. And in the discussion, I told her that every time you cheated on me, I forgive you, and the last thing she said to me was, "Who told you to do that?" And she just hung up on me and deleted me from everything. So I couldn't even talk to her. I couldn't even get down to the situation. So later on in the evening, I went out alone and I started drinking and impaired judgment. I didn't mean to cause any problems. I didn't get in an argument with anybody. I didn't get in a fight with anyone. I just was alone walking. I didn't mean to cause any problems. I didn't mean for this to happen. And that day was the worst day of my life. Even though I got arrested and I had to call somebody to pay my bond. Coming home to pay the person back when I went through my stuff. The people because I live in a boarding house with ladies and men from different countries. I never spent a night away from home. I came home and the money that I had saved up, $1,300, that was stolen. every day. That day was just the worst day of my life. Just the worst day of my life. I'm so sorry that I caused so much problems. Even in the Bahamas, I have a clean police record. I have 4 sons, and I pride myself in telling my sons that your father is 43 years old and he's never been to jail. I don't be in no problems at all. I was just having a bad day.
I can certainly understand that, sir.
I show myself on the mercy of the God, and I asked the God if they could give me one chance to prove myself. And I guarantee you, when I come back to Michigan, you would never ever see me in your courtroom again. I just was having a bad day, sir.
I hear you. I do. Mr. Brown talked about you being here on a work visa and going back to the Bahamas. Is that accurate?
Yes, sir. It's maybe between February 14, 13, and they give a day or two.
All right. So relatively quickly, you're not going to be here. Do you intend to come back to the United States at some point after that?
Hopefully, sir. Yes, sir. Because I really love it in Michigan. The people are nice and everything. So I really love it here. So I want to come back to work.
How quickly would that occur? Is there a specific amount of time that you need to stay in the Bahamas?
Yes, I think about 3 weeks or so to a month before I could come back.
All right.
Your worship, I really didn't mean to cause no problems. I'm not a bad guy.
I believe you, Mr. Wallace. I don't have any question in my mind that this was simply a bad day for you, but I'm really concerned that in the midst of having a bad day that you almost could have had a much worse day by getting yourself hurt by walking out into traffic. And then that grief, if it didn't kill you, that grief would have been transferred to somebody else because they would have been saddened and traumatized by having hurt you or hit you with their car. And I know that you didn't intend that, but sometimes when we drink, we don't always have the best judgment. And so that's my concern for you.
And that's why I could never be a judge, because I'm too empathetic. The judge sees it from that perspective, and the only perspective that was going through my head was how terrible those circumstances are for this poor guy and how bad I feel for him, and genuinely wishing that they had just gotten him a ride home that night, Oh man, it was bad, and then it got worse, and then it got worse, or
If you were staying here in Michigan, I would send you for a substance abuse assessment. But here's what I'm going to do instead, because you're leaving so quickly, and I don't know exactly when you're going to come back or if you're going to come back here. I'm simply going to say this. I think you need to have a substance abuse assessment, a drinking assessment to see if you have a problem. Maybe you don't. Maybe it was just a one-time thing, and they'll say that. But whatever they say, I think you need to do what they tell you to do so that it doesn't happen again, because I don't want to lose you and I don't want you to hurt anybody else if you get to that sad place again. You understand what I'm saying to you?
Yes, sir. But from the time period that has happened, I haven't drank or anything. But I understand where you're coming from. You're just trying to protect all parties. But sir, I am so sorry. If you give me one chance, to prove myself, I guarantee you you would never see me in your courtroom again. Just give me one chance to prove myself.
So I am going to do that. And the way I'm going to do that is this. I'm simply going to say that you owe me some fines and costs, and I'm not going to put you on probation. I'm not going to put you in jail. I'm not going to require you to go to substance abuse. I'm going to trust you that you're going to do what is necessary so that this never happens again. Does that make sense?
Yes, sir. May I say something too, sir?
You may.
Like I said, I've been sending my people, my family money. My mother's retired, so I have to help her with the rent. And since my money got stolen, it cost me to get back track. So right now in my possession, I only have like maybe $200 to $250 to $260 in my possession. I'll have to wait maybe another week before I see a paycheck. And even though another week it's gonna come up, my rent is gonna come out of that. So I don't know what I'll be facing. Maybe in another week I'll have altogether maybe 350
All right.
until
The
another
typical, yep,
I get
the
paid.
typical fines and costs would be $365, and I can give you until the end of February to pay that off. Would you be able to do that?
How much it is, sir?
$365, and you'd have until the end of February to do so.
Okay, sir.
That'd be-
Thank you. I really appreciate it. 365.
Yes.
Okay,
That's going to
sir.
be broken down as follows. It's $75 for crime victim rights, crime victim fee, $50 for a judgment, justice assessment, $150 in court costs, $15 in a local charge, and a $75 fine. You can pay that by 2/28 of 25. Then you don't have to come back to court, and I don't have to add additional charges to that. If you can do that, that'll be all that you need to do. And I'll just trust that you're going to take care of yourself and not get into this situation ever again.
Yes, sir. Yes, sir. I will, sir. Thank you, your worship.
You're very welcome. Good luck to you, sir.
My question is, I'm not from here. Where do I go to pay this?
You can contact, the notice that you got of today's hearing should have a telephone number on it for the district court. You call that number. If you call 731-0201, you can talk to the court about making payments, and you simply need to make them by the end of February.
By the 28th, right, sir?
Correct.
All right, sir. Thank you. I really appreciate it, your worship, for having some mercy on me.
Good luck to you, sir.
Thank you, sir.
He is so darn sweet. Oh my gosh. I like him. I know. He is so adorable and so sweet, and I feel so bad for him. That really was probably the worst day ever. Like, oh, poor guy.
You're welcome.
All right.
Who do we have from the jail? All right. Is that you, Ms. Brink, at the county jail?
Yes, sir.
All right, thank you. We're going to call your name, your case next, so let me find that on the docket here. All right, we'll call People versus Chelsea Brink. That's 25-43389-SM.
Larry Brown on behalf of Ms. Brink.
All right, looks like we're here for, I'm sorry, Ms. Brooker, go
Oh,
ahead.
go ahead. Amanda Brooker appearing on behalf of the people.
Thank you. Looks like we're here for a jury status conference. Do we have a resolution, Mr. Brown?
Your Honor, I don't believe there has been an offer in this matter. I'll defer to Ms. Brooker in case there has.
There's not an offer.
This is a simple assault, Your Honor. I believe I sent something to the court on this matter. It is my understanding that Ms. Brink, if it is acceptable, will be entering a no contest plea for any potential civil liability.
I do see an affidavit of probable cause, but I do not see any other documentation that may have been sent to the court today. Is there something specific that you think you sent, Mr. Brown?
That is.
I sent 2 pages that I believe.
Yep, I do see that now. Yep, I do see
what I sent.
All right, I just didn't know if there was something else specific that you had. So I have received those 2 items. All right, Ms. Brink, your attorney has said that he believes that you wish to enter a plea to the charge of assault and battery and plead guilty as charged. Is that what you want? Excuse me, plead no contest as charged. Is that what you want to do today?
Yes, sir.
All right, if you do that, you would be giving up your trial rights and you would not have a trial because you'd be telling me that you did something that was against the law. Do you understand that?
Yes, sir.
If you had a trial, you would have certain rights. So I want to tell you what those rights are so that you can make an informed decision. You have the right to have a trial by a judge or by a jury. You have the right to have the assistance of an attorney at that trial. You have the right to see, hear, and question the witnesses against you at trial. You have the right to call witnesses on your behalf and to get an order called a subpoena to require those witnesses to appear and testify on your behalf. You have the right to be a witness yourself or to remain silent. And if you choose to remain silent, that silence cannot be used against you because you have an absolute right against self-incrimination. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof be on the prosecutor at all times. Do you understand each of the rights that I've just read to you?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
Do you understand that if you enter a plea today, that you would be giving up, waiving, and not having any of those rights, other than you would continue to have Mr. Brown as your attorney?
Okay.
All right. Would you raise your right hand, please, so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, you can put your hand down. Has anybody promised you anything to get you to plead today other than what's been stated in court today?
No, sir.
Has anybody threatened you in any way to get you to plead guilty?
No, sir.
Are you doing so of your own
Well,
free
kind
choice?
of. Sean John Conrady gave me a look.
I'm sorry, who gave you a look?
It's the, Your Honor,
Sean John Conrady did.
it's the victim in the matter.
How is that making you do
He
a plea
peered
today?
over. Well, he peered over the cop's shoulders when I was, and during the course of the interaction, he reached for a knife. So I was intimidated and fearful of him.
Are you talking about at the time of the incident, or are you talking about today?
The time of the incident.
All right, I'm talking about today. Has anybody threatened you in any way to get you to plead guilty today?
Not today.
All right, is that time of the incident, are you telling me that you're acting today because you feel threatened today because of that previous incident?
In a way.
Well, here's the deal. If you're being threatened in any way, I'm not going to take a plea from you. You have to be doing this of your own free choice and free will. And if you're not, I'm simply not going to take a plea from you. I don't want anybody or you to feel like anybody is threatening you or doing anything that would take away your absolute choice in this matter. Do you understand that? All right. And now, in understanding that this is your choice and your choice alone, do you still feel that you're being threatened in any way to get you to plead guilty today?
I mean, I think the cop arrested the wrong person, but I don't feel like I'm being threatened necessarily. But I have nowhere to go if I'm let out of jail because Sean Don Conrady is still in my residence.
Well, we can deal with that later, but today is a day for whether or not you're going to plead. I can't solve all of your problems today. I just simply need to know that you're making this choice of your own free will and you're not feeling actively threatened today to make that plea. Is that true?
Okay.
That you're not being actively threatened today? All right. Then I will go ahead and continue with the plea. If you change your mind at any time, you let me know though, all right?
Okay. Thank
All right.
you.
So I'm going to ask you some questions about what you did. Is it true that on January the 5th of 2025 in Bagley Township of Otsego County that you did make an assault or an assault and battery upon Sean Conrady?
Your Honor, this is a no contest.
I'm sorry, that's true. That's a no contest plea. I apologize, Mr. Brown. Thank you. And you have sent to me, Ms. Brink, do you agree that I can look at some paperwork to determine whether or not you made a plea, an assault, so that you don't have to admit responsibility to that? Is it okay with you if I look at the police report and the affidavit of probable cause? All right, thank you.
Yes, go ahead.
Thank you for bringing that to my attention, Mr. Brown. I appreciate that. All right, I do find from the affidavit of probable cause that Chelsea Brink assaulted or assaulted and battered Mr. Conrady by punching him in the side of the head and neck with her right hand, and that there was a small red mark on the side of his head, and that this was an incident involving being upset about a DVD player and an Xbox cord at the residence in Otsego County, specifically 1336 Groveland Avenue in Bagley Township on or about January the 5th of 2025. I do believe that satisfies the proper factual basis for the charge. Any other questions as to factual basis, Mr. Brown or Ms. Bruker?
No, Your Honor, I believe there's a factual basis.
I
And do you
agree, Your
believe that we,
Honor.
thank you, Mr. Brown. Do you believe that we've also complied with the court rule for taking pleas?
Yes, Your Honor. I'm sorry.
Yes, Judge.
She beat him up over an Xbox and an Xbox cord. Yeah, that happened.
All right, Ms. Brink, do you still want me to take your no contest plea?
Yes, sir.
And do you understand that a no contest plea, for all intents and purposes, is exactly the same as a guilty plea?
I'm sorry. YouTube cut it off there. I did not. But it was still worth it. Here's another one.
This is file 24-02268 SC, JDAC Enterprises, LLC, Jeffrey Stevenson, plaintiff, Todd Shepard, defendant. Prior to beginning the hearing, I want to make sure that both sides understand that by being in small claims, you waive certain rights. You waive the right to be represented by an attorney. Excuse me. You waive the right to try the case to a jury. You waive the right to recover more than $7,000, and you waive the right to appeal the decision of the judge. If you stay in small claims, those rights are waived. If you don't want to waive those rights, this matter would proceed to the general jurisdiction. Mr. Stevenson, is it your intention to stay in small claims?
Yes, it is.
Okay, and are you also the principal person in JDAC?
Yes, I am.
Okay. And Mr. Shepard, is it your intention to stay in small claims?
Yes, it is.
And I would ask you to raise your right hands, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
I do.
Okay, thank you. The way we're going to do this is I'm going to ask a series of questions back and forth in no particular order. If I direct a question to you, I would ask you to answer it. If the question goes to another person, I'd ask you to let them answer it. When I'm done asking the questions that I think I need the answers to, I'll then go to the plaintiff, and the plaintiff will have the opportunity to present either testimony or documents that he thinks he needs to complete his case. When that's done, the defense has the same opportunity to complete their defense with additional testimony or documents as they see fit. If the defense brings up something new, the plaintiff would have the opportunity to respond to that which was brought up new. And after that, it's back to me and I'll issue a judgment. Mr. Shepard, I'm going to ask you the first question. And that question is that you have been sued for $1,607.22. Is there any portion of that that you acknowledge you owe?
Zero, Your Honor.
Mr. Stevenson, how did you get to the number 1607.22?
The amount was, if I remember correctly, $858 is what I invoiced for. With a, there was 1.5% per month for past due of a contract that Mr. Shepard signed. And then there were some small incidental, I had to have the Spring Hill Police Department submit the documents to them to bring them to small claims, and we tried another avenue earlier to that, so there were some costs associated with that, but that was rather small in the grand scheme.
Yeah, I'm showing a $50 filing fee, $10 certified mail fee, and an officer fee of $52.
That's correct.
That's it?
That's it from that. Yes, and the initial was $858, if I remember correctly, and the rest is interest as it went back to 2021.
Okay, can I see the document that you referenced?
Which
as to the invoice? This is an invoice addressed to Todd Shepard bearing the date 07/01/2021. Mr. Shepard, at some point in time, did you live at that address?
I did, and he did perform the work.
Okay, now as I'm looking at the invoice, I'm going to read what it says for activity. Water damage mitigation, content manipulation, packaging of retained contents in boxes, bagging up of items that were thrown out. Work performed was for contents only and did not include any charges for water mitigation. And that's the 858.71. Payments can be made via check made out to. If you preferred to pay with a credit card at 3%. Was there a contract, Mr. Stevenson, that was signed prior to?
Yes, June 24th. It's what we call a work authorization.
This is a 3-page document that bears the date, appears to bear the date 6/24/2021. And the description of event is handwritten and reads, contents repackaged after water loss. Items that are dry will be repackaged cardboard. Items wet will be held back for disposition. Wood furniture will be placed on blocks while the area is being dried. The second page is verbiage as to what they do and don't do, and all that's contract terms and conditions. There's a number of not applicables listed. Payment. If payment is made directly to the client by the insurance company, it shall be endorsed over to the company within 3 working days. Any and all charges for services not reimbursed by insurance company, deductible, excess costs, etc., are the sole responsibility of the client and to be paid upon the completion of the work. And Mr. Shepard, I'm going to try to show you the last page, and it appears to be dated 6/24/21. Are you able to see that page, sir?
I am. I can't read the written word, but I see my signature at the bottom, sir.
You do see your signature at the bottom?
I do, yeah, absolutely.
At the beginning of this hearing, I asked you if you acknowledged that you owe the plaintiff anything.
Yes, sir.
And you said no.
I did.
Okay. What is the basis for your statement that, first of all, I'm going to ask you, has this bill been paid?
It has not been paid, sir.
Okay. How come?
I was the tenant of one Miss Elise Applebaum. It was her house. Her sub pump failed. I notified the owner, Elise. She hired remediation to come fix it. It was her obligation to pay for remediation. This bill should go to Miss Applebaum 100%. I lived in the house, sir.
We didn't hire.
Why? You signed the contract, sir.
We didn't.
I signed it as an agent of hers to get the work done, sir.
There was nothing on this bill that deals with the various steps that would be taken that would be germane to the building. What I'm reading in the description of event is contents. Contents repackaged after water loss. There was no billing for cutting out drywall, bringing in fans to dry stuff out, bringing in dehumidifiers to dry it out, to install sump pumps to take the water out. This is all just dealing with the stuff that was in the house. And it's my impression, and correct me if I'm wrong, was the stuff that they worked with your property.
It was my property, but due to the failure of the house itself, which I spoke to Miss Applebaum about and said, we flooded and I lost the majority of the contents of my basement. She called out remediation. It is my belief that had there never been a flood, I would not have needed it. But due to the poor equipment in the basement, it caused me to lose a lot of my property. So yeah, it is my belief that she should have paid for this because it was her domicile.
Well, and she hired them. We didn't hire them.
Yeah, you did. Her signature isn't on this document.
I understand that.
If there was anything done by the plaintiff to deal with the flood and the damage to the building, that's clearly the landlord's responsibility. By perhaps contract theory, Applebaum should have paid your bill.
Mm-hmm.
But I'm looking at a contract that bears your signature. The client information is you. There's no Applebaum on this at all. Now, it's my impression or guess that the plaintiff also did work there that he billed Applebaum for. And I should note, because you can't see him, that he's nodding affirmatively.
He did all of the remediation. Absolutely.
Yeah. And, but this description of event is very clearly limited. The event as it is defined is limited to your stuff. And they did repackage some of your stuff, right?
He did, absolutely.
You didn't hire them.
Man, you might not have called them, but this is a contract that bears the signature that
Well,
you can see.
we've been renting for decades, and when we've had a problem, the landlord hires someone and we always have to sign because they're not at the property. We had no idea. If we knew we were going to be charged this, we would have done it ourselves. She was really wonderful and said, oh, I'm sending people out to take care of everything and then I'll fix the sub pump. We were in no position to pay that. We've had a horrible few years and we had no idea that we were going to be charged for this. And we have never gotten a bill ever from a property after a landlord's hired someone. And we've always signed for work. I just signed for a plumber a few weeks ago where we are now. So we had no idea that we were going to be getting a large bill.
I'm going to read you the last sentence on the last page, where it is authorization. As the client, I understand the work and accept responsibility to the company for services rendered. By signing below, I agree for the company to begin work and agree to all above terms and conditions. And the terms and conditions involve payment, involve 1.5% per month on the unpaid balance.
Well, what was also confusing about this situation was when we left the house, when we moved, she told us it was fine. We were moving because she wanted to sell the house. And then after we moved, her brother sent us a very threatening letter because he's a lawyer saying we would not be getting our deposit back and all these things. So we assumed that the same thing happened with this company because they have a history of not paying people back for things. And we just feel, I mean, my thought was maybe we were just the easy target because she had a brother who's a lawyer trying to get out of paying for things. If we knew that we actually owed that money, we would have paid it. And if we knew we had to hire them, we couldn't afford to pay that at that time. And we've had a really hard few years and we would have never hired them in the first place. She gave us the impression that she was taking care of everything and she felt terrible that she hadn't replaced the sub pump. So we thought everything was taken care of. And then we assumed after when they started calling us for payments, we said, please go to them. We did not hire you guys. And again, I guess it is confusing when you rent because we're constantly signing off on work done on homes. We had no idea that we would suddenly be getting a bill. And we would have had to figure out, we would have had people come help us clean that up. But we thought she was being kind and helping clean up because we lost so many of our things. And this was 4 years ago. And to get this bill now and have an officer come to our house was really upsetting. I just didn't, and we can't afford this right now. We've had a very difficult year. I can't work from an injury. We have kids trying to go to college. It's
Tammy,
just,
hold on.
okay, sorry. It's just very upsetting.
I know. So
I understand it's
Your Honor,
upsetting.
and I signed it in, to be honest, I signed it in good faith because he did the work. And I signed it in good faith because I knew that
Good faith was that you were going to pay him.
the good
That's
faith
what
was
the
that the
document
payment
says.
would be made, but the payment would be made by the landlord who owns the house that the damage was taken from. The damage was incurred because of the failure of the sub pump. That was her house.
You might have an action against the landlord.
Her brother's a lawyer. We'll never, the system doesn't work for people if you don't have a lot of money.
It's okay.
I'm sorry, I'm going to stop
Small
talking.
claims doesn't cost anything.
Her brother's a lawyer. They already kept our $5,000 security deposit. So the whole thing was just very frustrating. And then to lose half of our things in that flood, and now to have this come back at us 4 years later, I don't understand that either. Why is this? And then that's kind of a joke too. It's double the price. But again, we wouldn't have hired them if we knew we were getting charged. She called and hired the company. We signed off on everything
And
because
then
she was in Florida.
And then to tack on the usury charges, when I thought,
History is about 25%. This is 18.
oh, okay, it's 18%, but knowing that it should have gone to Applebaum and not myself. So I thought it had been taken care of, Your Honor. I would have.
I don't know why you would think that, sir, when the document says what it says. I didn't make up the document. Mr. Stevenson didn't just come up with it today. This bears your signature on the 24th day of June, 2021.
And I didn't hire him, to be honest. I did not. He came out because Applebaum had him come out. He cleaned up because Applebaum had him cleaned up. He came out and fixed what he did. I'm under the presumption that it is all based on that contract. I signed off that he did the work. Did I look through all the minutia? I did not. But this is, to me, this falls under the landlord.
You might well be right that the landlord owes you for it, but I have to tell you, sir, that this document is signed by you and it provides that you would pay. If you signed a document that you didn't read, that's not something the plaintiff can deal with. But the bottom line is, it says what it says, and they did the work. And this isn't work they did to the house. This is work that they did with your material, your stuff.
Yeah, but without A, we would have never gotten to B, right? If the house didn't fail due to the sub pump, this wouldn't have never happened. Therefore, it was due to the house that caused.
That doesn't change the fact that you signed saying you'd pay for it.
Okay.
She told us that she was gonna, don't worry about it, I'll take care of everything.
That's not between you and this plaintiff, that's between you and Applebaum.
Did the plaintiff send this to Applebaum to be paid?
Yeah. The question was, did you ever send this bill to the landlord to be paid?
Yes. So just for clarification, I did receive the call from Ms. Guerrero asking us to come out, and she gave us Mr. Shepard's phone number and set up the appointment. We did the exact same thing with her as we did with Mr. Shepard. We had separate work authorizations. Hers was for the structure of the house, drawing that out and so on. His was for the contents. We invoiced her on July 3rd, and we received money shortly thereafter. In my email that I sent on July 3rd, I highlighted to her that she had told me that Mr. Shepard was a tenant. And typically in the line of work I'm in, when you have a tenant, the tenants are almost always responsible for the contents, and the homeowner is responsible for the structure. And they're supposed to be self-insured on their contents and so on, regardless of what the reason was for the damage.
Yep. You pay him because he cleaned up your property. And then if the landlord said that they were going to cover that charge, you sue the landlord. And you don't want the lawyer brother involved, keep it in small claims. Because in small claims, you don't have lawyers.
So that's why I made sure that we had 2 work authorizations. On July 3rd, when I sent her the invoice, I said, I'm very concerned about getting paid by Mr. Shepard. You informed me, and he signed a work authorization. You informed me that he's responsible for the contents, and that you had that conversation with him. I was not privy to that conversation, but she went through all that with me. So we proceeded, but yet shortly after sending an invoice to Mr. Shepard, I immediately was concerned that I'm caught in the middle. And I even said that to her. I feel like I'm caught in the middle on this. She said she wrote back, I tried to reach him. He's not calling me back. That happened to be a holiday. However, it was July 4th. Never heard anything after that. I did ask for clarification coming into this in small claims. And she wrote to me, I asked, can you please state for the court what your position is on this? And she said, this is Elise Guerrero. At the time of June 2021, I had a tenant, Mr. Todd Shepard, lease my unfurnished home. She provides the address. I hired Jeff Stevenson to restore my basement of water damage, of which was paid in full and on time. Mr. Shepard was responsible for any work done, as well as costs associated with his own personal contents in the basement of this property. Elise Guerrero, and that was January 10th, 2025.
Well, what her statement says to her lack of responsibility isn't anything that we need to address because she's not.
Understand.
Mr. Shepard, did you have renter's insurance?
And to be honest, I can't recall. We usually do have renter's insurance. Jamie, I don't recall if we did in this. I know we do right now, but I can't recall if we did at the time.
Because whether it's a rental or a condo, there's basically two sets of insurance policies. One is for the building and the structures within the building, and the other is for the contents and anything inside the paint. In a condo, it's inside the paint, and in a rental, it's probably different. But the bottom line is that the insurance companies sell two different policies. One for the stuff that's in the building and one for the building. Now, if, for example, there's a leak and the carpet is damaged or drywall is damaged, those would be two different things because the drywall is part of the building and the carpet or rugs on the ground could be the property of the tenant. So I understand what you're saying when you say that Mr. Stevenson's people came out because they were directed to by the owner of the property, but their contract with the owner had to do with the actual structure of the building, and their contract with you had to do with the contents. And again, I'm not speaking to whether or not you have a cause of action against the landlord, but it isn't the plaintiff's obligation to make sure that you understand that when he's dealing with your stuff, it's going to be paid for by you over and above a contract, a 3-page contract that specifies that. It's preformed, it's printed, and many of the things, several of the paragraphs are not applicable, but the payment one is, and you signed it. You agreed to pay.
So the verbal contract I had with Elise that she was taking care of everything doesn't hold water here, right? Because it has nothing to do with
it. Has nothing to do with your contract with the plaintiff.
Oh, it's unfortunate, but I understand what you're saying. Because I feel as much as this gentleman, Mr. Stevenson, feels in the middle, so do I. I'm the one who took the hit on it. I felt that it was taken care of. It was not my intent to put this person in the rears in any way. However, I felt that the allegation and the understanding between Miss Elise and myself was that due to the problem, she was taking care of it. That's why we're here. But if that has no bearing on your judgment,
because it's between you and Mr. Stevenson. Statute of limitations on a contract is 6 years. So we're 2 years from the end of it. So we're sitting there in the middle third, the end of the middle segment, but it's still within the law, and he did what he said he was going to do.
Oh, he did. Absolutely, sir. He did the work. It's just Applebaum should have paid for the work. That's all.
I'm not disagreeing with you.
I know.
It's back. I'm not disagreeing, but the bottom line here is that I think you own the money. The interest is stated in writing in the contract. It is not usury.
I didn't even know this was still going on. So to have all these years of interest is hard too.
Well, you've had the money all that time. So it's 6 of one, half dozen of the other.
That's debatable because I didn't have the money.
Yeah.
We almost moved into our car 4 months ago. This is the horrific. I was injured. I can't work. I mean, this is just horrific to add on to everything. And it's so funny. We finally felt like we're getting somewhere now. And so then this shows up. I just feel like, so we don't have, I don't know if we can pay it in installments of $50 a month or something. I don't know what to do. We can't do any more loan. We can't.
Do you want to make an offer of installment payments?
Well,
I don't know what to do.
You're
We
gonna
don't
tell
have
us to
the-
pay
We
him.
can build that, we can build that into the judgment if it's agreeable to both sides.
Yeah, I feel that
Stevenson with $50 a month?
That's acceptable. It's gotta be.
Never
No.
stops.
No.
I was
The-
severely injured by a vaccine and I almost died. And it was going on during this whole thing. And they have the money. She's very wealthy. And she said, I'll take care of it.
She's not a party to this lawsuit, ma'am.
I know, I'm gonna stop now. Go ahead and just stop.
So we did try in the end of 2022, after I gave up trying to collect, we did hire an independent company, a collection agency, to try to go after it. And after 4 months, I relieved them from that. Primarily because I was told, and again, I had no contact with Mr. Shepherd at the time, but I was told that the discussions were starting to get a little aggressive. And so I pulled the person back. I have my reasons for why I did it now. We still have the interest on the money. If we get into payments, it's still the same interest that's there.
Okay. When the concept of $50 a month was put into the air, you rejected it. Is there a monthly payment that you would accept?
$250 a month.
Okay. Mr. Shepherd, I don't know if you could hear what Mr. Stevenson said, but he said he'd accept payments of $250 a month. If you don't want to commit to $250 a month, you're under no obligation to do so, and the judgment will enter, and then he's up. Then it would be collected by however it's going to get collected. But the bottom line here is, if you want to agree to a payment of $250 a month, then you would not be subject to collection procedures as long as you were current with that. If you don't want to, that's, if you can't do it, you can't do it. You don't want to agree to something you don't think you can do.
But if we don't, I'm trying to figure out how to pay him. So if it's not entered into judgment.
No, I'm saying it would be.
I know, but if it wasn't
It would be
entered
an
in,
installment judgment.
I'm sorry, if I wasn't entering it as 250 and I can't pay him in full, is it just between he and I as to how I can commit to paying him back? Or how does the judgment look, the settlement? Is it, I have to pay the whatever X amount it is in full? And if I don't,
if you have a judgment entered against you, it's your obligation to pay. If the defendant doesn't pay, then there's certain collection steps that a plaintiff can take. There's certain steps that can be done to attempt to collect on the judgment. Some of those are successful, some not. And one of the benefits of an installment judgment, that terms and conditions are agreed to by the parties, is that neither side has to get involved with the collection process. It's just done. And typically the plaintiff wants his money now, the defendant wants to pay later. That's nothing unusual about that. But the bottom line here is that both can be spared the grief of the collection process. It's not going to be easy. The collection process is never easy. And it can be irritating as well. But the bottom line here is I don't want you to commit to something that you don't think you can do.
do I have Mr. Stevenson's address to send money to, I guess is.
We can make sure that that's there, but before
I'm
we
not going
get
to
down
commit
to
to, I'm not going to commit to the 250 the gentleman asked for. I would just ask that I find a way to get money to him. And I just don't see anything on the documents that I have. Oh, I do.
You have a copy of the complaint that has his address.
Yes, I do. It's his business address, if that's okay with Mr. Stevenson. Sure. Okay.
That's his address. Now, Mr. Stevenson, the number you came up with was 1,650 something, I believe, 160722. Was that inclusive of any of the costs.
That has the interest as well as the separate fees of mailings and things like that.
Okay, so we're going to take $112 off and then add it in. It's going to come up net. But the 160722, we take off 102, that leaves 150522, and then we add costs of 102, bring us right back to 1607. So a judgment will enter in the amount of $1,622 this date. It will be mailed to both sides. When the judgment is mailed, they include some verbiage as to what people can do with judgments from either end, and that'll do it.
1622.
160722. Verify that again. 160722.
Thank you.
Is the total judgment. Judgment is 1505. Costs are 102. The total is 160722.
Still going to protest the interest, but I don't think it's going to matter.
It's not usury.
I know.
And it is in writing in the document.
I understand.
There are companies that will add this without putting it in the document, and that doesn't fly in court.
Okay.
But this is all stated out there in black and white, or in blue and white, whichever way you want to look at it, but it's here. So the judgment will be mailed to both sides.
Thank you.
Thank you.
This is super quick.
Good afternoon, your name?
Keely.
Okay. Keely Foster, right?
Yes, sir. Is my
File
president, is my
24.
attorney, is my attorney here?
Yep, he's right here. I'm looking at him. File 244373SM. In other words, this was just up for us to review bond. You were out on a PR bond, but you missed the court date, so it changed to a cash surety bond. So on this cash surety bond, you're in jail unless you make that bond. But I have already spoken to jail. I wrote right on here that it is okay to change to a PR if appropriate facility is found. So I know they're working with you to try to find the right place for you to go. If they find that place, I'm fine with you going there, and this bond will automatically change so that they can let you
I
out.
don't need to go. I don't need to go anywhere. I'm totally not suicidal.
Well, like I said, you're all set. You can stay in jail if that's what they think is best for you. And if you agree that some other place is better for you, I already gave you permission for you to go to the next place. All right.
So I can go
You'll get
home?
a next, well, not quite home, but somewhere else. The next court date.
No, what do you mean? What do you mean? What do you mean somewhere else? Why can I not go home? Why can
Foster,
I not
I
go
will-
home?
Miss
Why
Foster,
can I not go home?
I will call
Ms.
you and
Foster,
explain
just
that.
Take a breath. Your attorney will explain it to you. It's that there's two different plans, but I'm okay with either plan. You'll get
Why
your
can't
next
I go
court
home?
date in front of Judge Belargin. They'll hand that to you. But other than that, I think we're all set on this.
Why
Mr.
can I not go
Ms.
home,
Strasser,
sir?
anything?
If this could be set
Sir,
for
why
a
can I not go home?
sentence date instead of a next pretrial,
Okay,
and we can move it along.
Why
that
can
would-
I not go home?
I starred that so that the clerks will see that. All
Thank
right.
you.
Why
Thank
can
you.
I not go home? No, please
With
let
that-
me ask you something. Why can I not go home?
You can talk to your
Miss
attorney
Foster,
about that.
I will call you today at the jail.
And then because we're all set for weddings, you can go ahead and shut everything down. Thank you.
Oh boy, she gave them double birdies.
Two 4003081, the people of the city of Troy versus Jelani Walker. Morning. Can you state your full name for the record, please? Are you still using an address on Grove Street in Highland Park, sir? Today is the date and time that's been scheduled for a violation of probation arraignment. Before we get going with the arraignment, I'm gonna point out the obvious. You're here at the podium without an attorney. Do you understand that you have the right to be represented by an attorney at these court proceedings? And the reason that you have the right to be represented by an attorney is because anytime you come back to see me on a violation allegation, when you're on probation for a criminal offense, there is a potential for jail time. The range and the amount of jail time that could be imposed for a violation depends on the type of violation and the number of violations that you have. But that is a possibility for you at this point with the violation that's pending. Did you understand your right to have an attorney?
Yes.
And by declining to speak with someone today, if you're eligible to do that, are you representing to the court that you do not want to be represented by an attorney and that you're prepared to proceed and represent yourself?
Yeah.
All right. Do you have any questions about your right to be represented? Okay. Did you review the allegation that has brought you into court today?
Yes, I did.
So you've got 3 different violation allegations. They're all technical in nature. All 3 violations, if you're found guilty or you plead guilty to these, no more than 15 days in the Oakland County Jail is your maximum penalty for violations today. Do you understand that? Do you also understand that if you want to challenge or contest any or all of these violations, you have the right to have a hearing?
Yeah.
At that hearing, if you decide to exercise your right to have the hearing, the prosecutor for the city of Troy would be required to come into the court. They have to present evidence to prove each violation, and they have to meet a preponderance of the evidence standard in what they produce. So that burden is a lot lower than beyond a reasonable doubt, which is required to prove your guilt at a trial. This is that it's more likely than not. That's about the amount of evidence that they would have to produce to prove a violation. Do you understand that burden and your right to a hearing?
Yes.
Knowing that you have that right, and discussing the potential maximum jail penalties, how are you proceeding today as it relates to the allegations that are before the court? You can start by telling me, do you intend to plead not guilty and request that this case proceeds to a hearing? Or you understand that you could have a hearing, that you'd be entitled to have one if you choose, but you're waiving that right because you intend to plead guilty?
Well, 2 of them plead guilty to the first technical violation. I'd like to plead not guilty.
Okay, so the first one is an allegation that you had not been fully compliant with the random testing program. And I believe that it has to do with a test date of January 19th, where it's alleged that you did not show up. Oh, there's also a number of other dates, the 22nd, the 14th, and January 4th. So those are the allegations that fall under technical violation number 1. The way that we would proceed here, because I have no ability to just dismiss certain things because someone appears before me and decides they would like to plead guilty to others. So if you're contesting this violation allegation and the number of missed tests that are alleged here, we would probably need to set it for a hearing so that the prosecutor can come to court. And if they have evidence that they want to present that would prove to the court that you didn't show up on these dates, we could address that in a hearing. And then you could decide how to proceed with violation 2 and 3 at that time as well.
Yeah, because usually when you meet with the prosecutor, they can roll all those things together and do a global resolution and help you out. Probably a really good idea. About as good of an idea as getting representation.
I'll plead guilty. Can I explain?
Well, of course you can explain, but I don't want you to rush to change your plea. And I'm also curious as to why you were not inclined to speak with an attorney about all of these things, because they might be able to answer some of your questions about the process, so you don't feel like you're pressured to do something just to get things done today. Is there a reason that you did not want to seek the representation of an attorney today?
No.
Do you, and I'm just looking back here, so I know that you did have a retained attorney for the underlying case. So I can't automatically make an assumption that you'd be eligible for court-appointed counsel. But if you believe there's a chance that your current financial situation would support the court appointing someone to work with you today, I'm thinking it might be best to just pass the matter, have you fill out the form, and if you are eligible, you'd at least have an opportunity to consult with an attorney before you make any decisions.
I just want to
Okay, so you would just like to proceed without an attorney?
Yes.
And do you have a fair understanding of the things that I'm explaining to you about the hearing and the use of the hearing if there's one allegation that you want to contest?
No. No, he doesn't, Your Honor. No.
Yes.
And are you on your own without any pressure or other influence here deciding you no longer want to have any sort of hearing on any of the violations?
Yes.
Okay. So going forward then with the plea, the allegations that I already outlined regarding the missed test dates, knowing that you will be able to provide whatever explanation that you'd like once we get through the process of the plea here. How do you plead to the allegation that you did not appear for testing on the dates that I've outlined on the record? How do you appear, how do you plead for the, to the allegation that you didn't go in for the treatment orientation that was ordered by the court? And then how do you plead to the allegation that you did not document the substance abuse counseling that was ordered at the time of sentencing? Okay, I will accept your pleas at this point. You took a look at the summary report that the PO prepared, correct?
Yeah.
And there's some recommendations in there about a sanction that the PO thinks might be appropriate given the circumstances, but what do you want me to consider before I determine a sentence?
Well, I came prepared to, say these 15 that I owed for. I was unaware of an appointment on the 13th to meet with the commission department. And other than that, that's really it. But the scheduling dates that I missed, I spoke to the probation officer, Ms. Harmon, and she asked for my work schedule. I provided that so that I would not be mandated to go during my work hours, and that didn't seem to go through because I'm still being asked to go on days when I can't be there.
Oh, you're so cute. You gave them a schedule and asked them to schedule your drug tests around your schedule? I'm amazed.
There are no days that you would miss testing because of work.
On Saturday and Sunday, they close before I'm out of work. So.
Okay.
I don't know how that would work.
Okay, so are you representing to me that all of the dates that you missed are on the weekend?
No, I'm not saying that at all, but the dates that I have missed are during the work hours.
Maybe it would be helpful to have Ms. Harmon come down here and explain, I don't have any background on you providing work information.
Yes.
Where you're believing it's in conflict with what you're asked to do for testing. I did have some recollection of basic information that I had for you. Are you still working in the same job that you were at the time of sentencing with Spectrum?
Yes, ma'am.
And just give me a general sense of what your work schedule is.
Well, my work hours are typically 6:30 a.m. to 2:30 p.m. But sometimes I'm mandated, so I'm required to stay there later. So 6:30 a.m. to 11 p.m. or 6:30 a.m. to 8 p.m. But typically 6:30 a.m. to 2:30 p.m.
So, I mean, what you're telling me is that it seems like it will be impossible for you to do the random alcohol testing?
No, it's not impossible. I've completed many days and they've all been negative, but specifically, it's almost impossible.
So you're working every weekend?
Yes, I work every day except for, I'm full-time at work and I go to school on Tuesday and Thursday. But I work every day except for Tuesday and Thursday.
The recommendation here is to switch your alcohol testing to a different device.
Right, I'm focusing on the phone about the device I could use 3 times a day.
Yep.
And or I'd rather come to a court date so I could have a chance to stand before you and I guess explain my case. I didn't want to use the device because it would charge me $6 a day, and I feel that would just improve or increase my costs. Staying with the random testing.
So the recommendation that's being made today is for a device that costs more than that.
Right.
But the issue that we have here is that I don't have enough information about the discussions you've already had with your PO about your work schedule.
When I first came to the court date, I spoke with her and she asked me to email her my schedule. And I emailed her my schedule, and she said that would be sufficient to provide the reasoning as to why I can't be there at certain times. And I did that, and under the assumption that I won't have to be there Saturday or Sunday because they're closed at that time.
But there would be no ability for you to just not test on the weekend if you were
Okay.
working. You wouldn't be able to be on probation. So the alternative for many people, when they feel like their work schedule is not consistent, or it can go from 6:30 in the morning till 11 PM at night, which is what you've just represented to me, is that they're not going to be under the impression that the random testing would be appropriate for them. But I feel like you kind of feel like there's not a good option that you'd prefer. I can't.
I want to stay with the random testing. It's just that the Saturdays and the Sundays are difficult because they close at 11 AM and I'm at work.
Okay.
Unless I work together with my manager, then I don't see that being the case.
And unfortunately, this is sometimes a situation where, although people don't want to include their employers because it may impact their employment or make them appear in a negative light to the employer, I mean, you have to make a decision about how you will comply with conditions of probation when you're on probation for drunk driving. Sometimes this means asking your employer for concessions. Sometimes this means changing the type of employment. But you have several options that could be available to you so that you could easily test and maintain your current work schedule. You can either use a portable device and test on it, or we can do the tether that's recommended today. Those are both going to provide the test results that the court needs to keep you on probation. Or you could ask your employer to make a concession so that you can consistently show up for testing, including on the weekends. I can't fix all of those things for you. I always like to bring people back to this point that I'm sure it's going to sound very, very, very harsh, but it's the reality of it. I know you need to work, and I respect that you're trying to work and go to school, and I remember that you have plans for the future as far as what your career goals are. But at the end of the day, if you want to be on probation and you can't comply with the conditions, the outcome is typically some sort of jail sentence. And when that comes about, all of this work that you're doing to maintain your employment and not involve your employer kind of goes out the window because the court will end up putting you in jail and you won't be able to go to work.
And, you know, hypothetically, or I botched that one. I was going to say, the judge said, you know, he has dreams and plans. Well, you know, the hypothetical family that you hit when you were driving drunk, you know, they had plans and dreams too. Thank God that didn't happen. But you're suffering the consequences of your actions now, and you need to deal with them and not expect the court to, you know, kowtow around your schedule.
That makes sense. So I don't want to sound harsh, but I'm hoping that you kind of get a sense that once you're placed on probation, I will actually go, I think, probably out of my way sometimes to make things convenient for people to be able to work. But there's not going to be a situation where you just won't be testing on certain days of the week because you're working. Okay, so we can have you revisit the issues with Ms. Harmon. Either commit to the random testing schedule that you've already been given and figure out a way to make it work with your employer. Or you can switch the alcohol testing to the portable device, and whatever drug testing is still needed can be figured out and worked around your schedule. Does this make sense?
It does.
So I will make it really clear to Ms. Harmon that you've been given that choice and you're going to commit and you are going to commit to one or the other today. And I'll hold off on doing the tether because the tether is probably, depending on where you pick, $10 to $11 a day. So that's a significant jump even from the device that you previously declined. So I'm not going to go there, but you will be attending the treatment orientation on Monday, and you'll need to have something set up for counseling by the end of the week next week. So it's basically like a restart. But I just need you to kind of reevaluate how you're looking at things. Work is very important. Education is very important. But all of those things can be completely disrupted if you can't also figure out how to prioritize the things that you've been asked to do on probation. Does that make sense?
Yeah.
And I saw your PO just literally walked in the door, and I think we were about to wrap up here, but we were just having some discussions about the work schedule and that he had submitted some things to you. He thought that what he submitted would be sufficient to sort of excuse him from testing altogether on certain days, perhaps on the weekend, because he was reporting he works through the hours that the facilities are open. And I was explaining to him that I haven't been able to review the documentation, but that if that really is the case, it sounds like he needs to pick another method of testing.
Well, I do believe we discussed his work schedule and maybe the timing of the test, Your Honor. I don't have my notes in front of me, but I don't generally approve an entire day being missed of testing, and that's why I was trying to get him on the sober lane to avoid further issues.
I think we're on the same page at this point. I think his understanding was that if he's working from 6:30 in the morning until 2:30 on Saturdays and Sundays, and the facilities are never open past that time, that should give him a pass for testing on the weekend. And I've explained to him that wouldn't give him a pass, that really requires him to pick a different method of testing. So he was gonna talk to you about the portable as opposed to the tether, which I know you recommended. But we're gonna go back and revisit that because he's also very concerned about the cost, the tether being twice as much as the portable. But I think we might be at the same point now in our thinking that he probably will need to revisit the type of testing and switch to the portable if he doesn't want to look at changing the work schedule.
We do also have a couple agencies that are open later on the weekends, but they just might be a little further away. Like TAP has Saturday afternoon.
And I talked to him about that as well, that I really don't have a problem keeping him on the random testing, which it sounded like he was somewhat preferring, but it has to be random testing that he can avail himself of 7 days a week. So we were just gonna have him sort of circle back with you on that.
Okay.
But I think he has a better understanding now, why in some circumstances, offering a different method of testing is not necessarily a punishment.
Right.
But I think because of the change in the cost, he was concerned about that and didn't just outright accept it, but he's gonna participate in the treatment orientation on January 27th and have some updated counseling information about his efforts to secure something by the end of the week next week. And he was going to make a pretty significant payment. Is that what you just told me? A huge payment today. So obviously he's working hard to be able to get the balance taken care of. So that is very impressive.
Okay.
And he's on probation for 12 months already, and he's just placed on probation. He wouldn't be eligible for early discharge for 90 days, but I don't really think that changes his first eligibility date.
No, I wouldn't.
But I'm gonna decline to extend right now, and we're just gonna see how things go. Okay, all right, thank you. Mhm.
Oh goodness, that was so much fun with you guys. Oh yeah. I had fun putting that one together. I really did. The all night marathon of watching court and then editing and then making the thumbnails, and it's just, I love it. I love it. I thought you fell asleep. I almost texted that in the chat too. I was gonna say, I think my Morty love fell asleep. Thank you, Fozzie. I love finding stuff to share with my friends. That's the only reason I do this, is to share it with my friends. You guys are the absolute best. You make my night. Sir Philip, I love you. I love you, Eileenie Carlin. Just a titch. Just a teensy weensy little bit. You know, in Discord, Sir Philip has his own special horn that he can sound. I love you, Nana Laura. All right, guys. I'm off to do it again. I love you, Spider-Man, Mr. Pork Rinds, and Ice Cream Breath, and Pepsi. Oh, you guys all have the most wonderful night, and I will see you again soon, I promise. Be safe, be well, sleep sweet, and much love.